You're listening to an Airwave Media Podcast.
Happy New Year, everyone, and welcome to 2025 and the start of the 18th year of the Useless Information Podcast. It just seems crazy to me that I've been recording that long. I should also mention that this year also marks the 31st anniversary of where it all began, where I first posted these stories, and that was on my Useless Information website. And while I was putting together today's story, it got me thinking back to a threatening legal letter that I received in the mail shortly after I launched the website. And I'm guessing this would have been in the mid-1990s, maybe about 1995 or so. But I guess I should back up a bit before I tell you why I got that letter. You see, when I first started using the internet, it was all text-based, these really long commands you had to type, and it was incredibly cumbersome to use. But then I started reading about this new thing called the World Wide Web, which would speed things up. You just point and click and something loads. And after someone showed me a web page for the first time, I was hooked. I immediately went home and decided I needed to create my own website. The problem was that I didn't know what to put on a web page, and that's mainly because there were so few of them out there. So I decided to take the text of some emails that I had sent to my friend Jamie and just kind of use those as dummy text on this website that I was creating. I really didn't know what the end product would be. And for lack of a better title, I remember that a former student of mine had mentioned that I knew more useless information than just about anyone else, so I just stuck that title on the homepage. Honestly, if I had even the slightest inkling that I'd still be using it all of these years later, I definitely would have opted for a different name. But now I'm just kind of stuck with the useless information moniker. It is what it is, and I'm not about to change it. Anyway, those early stories were things like, who invented the Post-it note, the invention of Lionel trains, and how they printed the M's onto M&M candies. And it was that M&M story that got me in trouble. You see, one day I went to my mailbox and in there was a letter from the lawyers at M&M Mars warning me that M&M's was a registered trademark and I had absolutely no right to use it. It was your standard warning letter. I'm betting they cranked out tons of these to anyone who used the word M&M on the internet. But it was written with enough legalese to scare the pants right off of me. My initial hunch was that I was protected by my freedom of speech, but keep in mind this is the early days of the web. No one really knew what you could and couldn't do. I mean, the last thing I wanted to do was be the test case to find out. I'm thinking me, a lowly paid teacher, versus the largest privately owned corporation in the world. Who do you think's going to win that court case? Probably not me. And the reason I mention this is that history has shown that with each new technology that comes along, there's always legal questions that need to be answered. I'll just give you a few examples here. The invention of the printing press. I'm certain that brought up the issue of whether or not governments had the authority to regulate or censor, published content. Similarly, the advent of the telephone sparked debates about the legality of listening in on one's private conversations. And more recently, the use of DNA, from the Ancestry-type databases, they're using that in criminal investigations, and that's prompted discussions about privacy and, of course, the boundaries of lawful evidence collection. And we certainly can't ignore all the legal questions that are now emerging with the influx of AI technology. Of course, I could provide countless examples, but the key point is clear. That is that the world is constantly evolving, and history has shown time and again that laws often struggle to keep pace with advancements in technology. Well, coming up next, I have a story involving a legal question that popped up with one of these new technologies. That was photography. On its face, we're presented with what seems like a simple question. If you go to a studio and have your picture taken, do you own your picture or do they? Can they turn around and resell it, or do you get to say what happens with it? You would think that you do, but then maybe you don't. Well, stick around because this is a story with some great twists and turns. Plus, as you'll soon hear, the young woman who's the focus of the story will get the last laugh in the end. I just love when that happens. I am Steve Silverman, and this is the Useless Information Podcast.
Useless information.
Today we take photography for granted. You just pull out your smartphone, snap countless photos, and the cost, well, nothing more than the phone itself. It's basically free. But it wasn't always that way. The first permanent photograph is believed to have been taken by French inventor Joseph Nicephore Niepce in either 1826 or 1827. What he did is he took a pewter plate and coated it with a naturally occurring tar known as bitumen of Judea. Then when he exposed it to sunlight, the brightest parts of the image that would harden the bitumen, while the lesser exposed areas, those would remain soft, and he'd be able to wash it away, and what he was left with was a permanent image. This process required about 8 hours or more of exposure, but what he did is he captured the view of the courtyard outside his window. And it's that photograph, which is titled View from the Window at Le Gras, which marks the dawn of photography. A couple years later, he joined up with artist and scientist Louis Daguerre to further develop the process. And together the two explored the use of other chemicals and materials and chemical treatments, but sadly Niepce passed away in 1833. Of course, Daguerre continued on without him, and in 1839, he introduced the daguerreotype, and that would be the first commercially viable form of photography. After that, photography quickly evolved. First, it was Henry Fox Talbot's calotype process, and what that did is it created negatives on coated paper. By putting it on coated paper, you can make multiple prints from a single exposure, something that you couldn't do with a daguerreotype. The next major development was Frederick Scott Archer's wet collodion process, and that produced images on glass plates. The main advantage of that is that it greatly reduced exposure time. But the big disadvantage was that it took a lot of time to prepare the plate. You'd pull out the glass, pour the chemicals on, and so on, and then you could take your picture. Well, that was solved by Richard Leach Maddox with his dry plate method. Not only did this make photography more convenient, but it also allowed photographers to capture images more spontaneously. Without all the setup, you could just pull out a plate, stick it in your camera, and snap the photo. But let's face it, all these developments were great, but none were simple. You still needed some level of technical mastery to capture and develop an image. Well, that would all change in 1888 when George Eastman invented flexible roll film, and then he introduced his Kodak camera to the masses. Basically, now all one needed to do was snap the pictures, mail their entire camera back to Kodak, and they would take care of the developing and printing. Next thing you know, the post office delivers back your photos and a camera loaded with a brand new roll of film. Their slogan, "You press the button, we do the rest," it said it all. But I should point out that it was expensive. The camera, preloaded with a roll of 100 exposures, so it could take 100 pictures, it cost $25. That may not seem like much today, but adjusted for inflation, that's about $860 today. Once you took your photos, you'd mail it back to Eastman's headquarters in Rochester with $10 for processing. That's around $345 today. Now think about that. That's about $3.50 per picture to develop it. Without a doubt, that was crazy expensive initially, but the cost quickly dropped, and by 1905, nearly 1/3 of the United States population had taken up photography. Suddenly, people were taking photos seemingly anywhere at any time. And even worse, they could do nearly anything that they wanted with those photos. The reality was that the bulk of the laws on the books at the time had not been written with photography in mind, and that's why anyone could do anything with the photographs. Well, back in 1900, 17-year-old Abigail May Roberson found herself in such a predicament, one that the legal system had never dealt with before. At the time, she was living at 101 Caledonia Avenue, which is now Clarissa Street in Rochester, New York. In a 1967 interview, Abby described her shock as she peered through the glass window of a grocery store located in the city's Four Corners neighborhood. What she saw was herself, and it wasn't her reflection. Unbeknownst to her, the Franklin Mills Flour Company had used her face on one of their advertising posters. She would later learn that approximately 25,000 copies had been printed and distributed throughout the United States and Canada. Abby would never learn how Franklin Mills had obtained a picture of her, but one thing was certain. She had never given them permission to use her image. They hadn't asked, nor had they paid a single cent to do so. Even if they had asked, she definitely would have turned them down. In that same interview, she said,
I was dating a Jewish boy then, and he was waiting for me to grow up so that I could marry him. He was good friends with another young man who did wonderful artwork, especially portraits. Well, I had some pictures made of myself at a studio nearby, and my boyfriend told me that his friend was going to do a portrait from it and later showed it to me. Little did I realize what they were going to do with it. I knew when I saw it in the store window.
One thing that was certain was that there was no question as to why Abby's face was selected for that advertising poster. She was gorgeous, and that fact was repeated over and over in both contemporary newspaper accounts and court documents. The April 2nd, 1901 edition of the Rochester Democrat and Chronicle newspaper stated, quote, Miss Roberson is a magnificent brunette whose attractiveness has not been exaggerated in the newspaper accounts of the action, unquote. Printed on rough white paper, the poster in question measured approximately 22 inches wide by 30 inches tall. That's about 56 by 76 centimeters. Abigail is pictured, it's a large picture of her. She's pictured from the shoulders up, looking away from the camera. Above her head, there's text that reads, quote, Flour for the family. At the bottom, of course, it says Franklin Mills Flour. And then in tiny print in the lower right-hand corner is information about the printer. Quote, Rochester Folding Box Company, Rochester, New York, unquote. It was all tastefully done, but Abby was extremely shy at that young age, and she pointed out that she
couldn't even talk with people, and when anyone made fun of me, I'd just stand rooted to the ground, burning with a blush.
It was widely reported at the time that the sudden attention caused her to collapse from, quote, nervous shock, unquote, and that forced her to seek medical care and be confined to bed. And while that was true, it wasn't quite the whole story. In reality, Abby was an unhealthy young woman.
Of course I was in bed and had to have a doctor because I was already an invalid and had to be in bed. Those doctors had told me years before that I wouldn't live until 21. They said I had a bad heart and one lung and gosh knows what else.
As we will learn later in the story, she will outlive them all. Abigail Roberson turned to the court system to stop further printing and distribution of the posters. Attorney Milton E. Gibbs was hired to file the paperwork and represent her in court. Since she was 17 and still a minor, Abby was considered an infant under the law, so the lawsuit proceeded with her mother, Margaret E. Bell, named as her guardian. A little side note here is that Abigail's father, James, had died in 1892, so her mom took George Bell as her second husband. Sadly, he died shortly after they wed, so she became a widow for the second time. Abigail made no claim of ownership over the posters. Instead, Attorney Gibbs argued that their printing violated her right to privacy. She had paid for her photograph to be taken, retained full ownership of it, and had never transferred those rights to the defendants, that's the Rochester Folding Box Company and Franklin Mills. Their actions, he asserted, had caused her significant harm, including, quote, great injury to her nervous system, unquote. In addition to halting the distribution of the posters, as compensation they sought $15,000 in damages, which is equivalent to nearly $560,000 today. Now, before proceeding further, it's important to note the hierarchy of the New York State court system. Unlike most other states, in fact, I think all states, the Supreme Court in New York is not the highest court in the land. Instead, it serves as a trial court. Decisions from the New York Supreme Court can then be appealed to one of four appellate divisions, and they function as kind of intermediate appellate courts. And if you would like to appeal it further, then you go one step higher. That's to the New York Court of Appeals. That is the highest court in New York State. It would be on Monday, June 25th of 1900 that New York Supreme Court Judge John M. Davey first heard arguments from both sides in the case. Elbridge L. Adams, who represented the defendants, moved to have the case dismissed, arguing that since no laws existed to prevent them from using her picture, they had every right to do so. But Attorney Gibbs insisted that since Abby wasn't a politician or someone in the public eye, she had a right to privacy.
In this case, however, here is a modest young girl of the city. Certainly she has the right to protest against this promiscuous use of her picture.
Justice Davey commented,
If the picture tended to bring ridicule on a lady, then it would be termed libelous. But would a picture of this kind, lovely as it is, be libelous? The question is, have they a right to circulate this picture? The question of damages, it seems to me, has very little to do with it.
Well, both sides would have to wait for a ruling, but the headline in the July 31st, 1900 edition of the Democrat and Chronicle summarized his findings. Quote, Girls portrait her exclusive property. Judge Davey's decision in a pioneer case of interest. Unquote. They publish his opinion in its entirety. I don't want to bore you with all the legalese, so here are just a few highlights of what he wrote.
She is undoubtedly a young woman of rare beauty, and this she enjoys as a private citizen. It is very natural if the plaintiff is of a modest and retiring nature that any such publicity would be extremely disagreeable and offensive to her. It is not impossible, therefore, that she has suffered and continues to suffer great mental injury and distress.
He went on to say,
It seems to me that the sale and circulation of lithographic copies of plaintiff's likeness without her consent is an invasion of her private rights. Every woman has a right to retire from the observation of the public. Her face is her own private property, and no photographer would have the right to take advantage of the privilege of taking her photograph for her own private use to make copies from the negative and sell them to the public. It would be a breach of trust and confidence placed in the photographer, and, I might add, a breach of an implied contract that he would not sell or exhibit them to the public without her consent.
7 paragraphs later he writes,
If her lithographic likeness, owing to its beauty, is of great value as a trademark or as an advertising medium, it is a property right which belongs to her and cannot be taken from her without her consent. She has a right to say that without her consent, these lithographic copies of her likeness shall not be circulated or used by the defendants.
He then concludes,
After a careful consideration of the novel and interesting questions raised on the demurrer, I have reached the conclusion that the plaintiff is entitled to the relief demanded in her complaint, and to refuse her that relief would be to admit that a wrong has been committed which causes her severe mental pain and distress and pecuniary injury, and yet the law can afford her no relief. Such a rule is contrary to my views of equity jurisprudence. The demurrer, therefore, is overruled with leave to the defendants to answer on payment of the costs.
It was immediately clear that the defendants planned to appeal the decision, but Abigail had already won on one minor point, and that was that production of the posters with her face on them, it ceased. Of course, that didn't eliminate all that had been previously distributed, but no additional copies would be printed. The Appellate Division, 4th Department in Rochester heard the case not once, but twice. This was necessary because one of the judges who initially presided had resigned. It should also be noted that Chief Presiding Justice William H. Adams had to recuse himself both times, and that's because his son Elbridge was representing the defendants. Their decision, handed down on July 23rd of 1901, upheld the lower court's ruling. And here's just one paragraph of Justice William Rumsey's opinion.
That one's features or limbs may be in themselves profitable to the possessor, especially if they are of noticeable beauty, cannot be denied, and so far they constitute a right of property which the court will protect. The peculiar formation which made the Siamese twins unique was undoubtedly exceedingly valuable to them, and the courts would without question have protected them against any efforts made without their consent to photograph or by picture to produce a counterpart of that formation for the purpose of exhibition, and thereby reduce the profits they might receive from the exhibition of themselves. So if the face of a woman by reason of its beauty is especially valuable as a model from which the picture of a Madonna could be painted, there can be no doubt that any attempt by photograph to reproduce a face so that it might be sold to a painter, thereby depriving the owner of the opportunity to obtain for herself the profit arising from it, would be a violation of her right of property and would be restrained.
Abigail had won once again, but the defendants, well, they weren't giving up. They still had one last chance. That was the New York State Court of Appeals in Albany. Well, they handed down their decision on Friday, June 27th of 1902. In a 4-3 ruling, Abigail lost. The prevailing opinion was written by Chief Justice Alton Parker, and I have to tell you, it is quite lengthy, so I've selected just a few key paragraphs to share with you.
It will be observed that there is no complaint made that Abigail was liable by the publication of her portrait. The likeness is said to have been a very good one and one that her friends and acquaintances were able to recognize. Indeed, her grievance is that a good portrait of her, and therefore one easily recognized, had been used to attract attention toward the flower company advertisement. Such publicity, which some find agreeable, was to Abigail very distasteful, and because of the advertiser's impertinence in using her picture without her consent for its own business purposes, she claimed she had suffered mental distress. Others might have appreciated the compliment to their beauty implied in the selection of the picture for such purposes, but it was distasteful to her.
He continues.
The so-called right of privacy is, as the phrase suggests, founded upon the claim that a man has the right to pass through this world, if he wills, without having his picture published, his business enterprises discussed, his successful experiments written up for the benefit of others, or his eccentricities commented upon either in handbills, circulars, catalogs, periodicals, and newspapers, and necessarily that the things which may not be written and published of him must not be spoken of him by his neighbors, whether the comment be favorable or otherwise.
Further on in his decision, he writes,
if such a principle be incorporated into the body of the law through the instrumentality of a law of equity, the attempt to logically apply the principle will necessarily result not only in a vast amount of litigation, but in litigation bordering upon the absurd. For the right of privacy, once established as a legal doctrine, cannot be confined to the restraint of the publication of a likeness, but must necessarily embrace as well the publication of a word picture, a comment upon one's looks, domestic relations, conduct, or habits.
Yes, that was one long run-on sentence. Anyway, you get the idea. What he said was that basically there's no right to privacy established in the law. He also seems to suggest that she should have been flattered that they chose to use her image, and if they had ruled in her favor, it would have just opened the floodgates for lawsuits by anyone else who ever felt any sort of mental distress. One thing that Judge Parker did point out in his decision was that it was within the power of the state legislature to enact laws that would protect one's privacy. And that's exactly what they did. Just a short time after he handed down his decision, in 1903, the state enacted a right to privacy law, although I should point out it's fairly limited in scope. Basically, it prohibited companies from using a person's name or likeness without their consent, and of course that's a law that's since been adopted by many other states and jurisdictions. Needless to say, Parker's decision was deeply unpopular, and his words would come back to haunt him. In 1904, while running as a Democratic candidate for the President of the United States, Parker became annoyed by the constant intrusion of the large number of photographers attempting to snap pictures of him and his family. So while at his home in Esopus, New York on July 15th of that year, he announced that he was done with having pictures taken of him.
I reserve the right to put my hands in my pockets and assume comfortable attitudes without being everlastingly afraid that I shall be snapped by some fellow with a camera.
That story was picked up by the wire services and printed in newspapers all across the nation. One observing reader was a young woman in Rochester. Can you guess her name? You got it right, Abigail Roberson. And she penned the following letter to Parker, and it is brilliantly written, so I'm going to present it in its entirety.
Rochester, New York, July 20th, 1904. Honorable Alton B. Parker, Gasopus, New York. My dear sir, I read in the Associated Press dispatches yesterday afternoon that Mrs. Parker was obliged to leave home to avoid the annoyance of ubiquitous photographers, notwithstanding the warning given by you and reported in the same dispatches last Saturday morning, in which was announced that that would be the last day of promiscuous photographing of yourself and family, and wherein you are quoted as saying, quote, I reserve the right to put my hands in my pockets and assume comfortable attitudes without being everlastingly afraid that I shall be snapped by some fellow with a camera, unquote. I take this opportunity to remind you that you have no such right as which you assert. I have very high authority for my statement being nothing less than a decision of the Court of Appeals of the state wherein you wrote the prevailing opinion. The action was one in which I was the plaintiff and Rochester Folding Box Company and another corporation were the defendants, and is reported in the 171 New York at page 538. You may recollect that the facts in the case were undisputed, and that it was admitted that the defendants, without my knowledge or consent, and knowing they had no right or authority to do so, had secured my photograph and having caused it to be enlarged and lithographed in life size, had circulated about 25,000 copies thereof as an advertisement of the commodities in which one of the defendants dealt. That the likeness were posted conspicuously in stores, warehouses, saloons, and other public places, and had been recognized by my friends and others. That my good name had been attacked as a consequence, and that as a result of the shock and mortification upon my ascertaining that I had been made public property in this manner, I was actually confined to my bed with nervous troubles and placed under the care of a physician. That such use of my likeness was being continued, and that I desired an injunction against the defendants restraining the further use thereof. The question arose upon demurrer, and the special term held at the complaint entitled me to relief. The Appellate Division of the Fourth Department unanimously affirmed the decision, and upon the appeal to the Court of Appeals, this latter court was divided, 3 of the judges deciding with you that the facts admitted no ground for relief, and 3 dissenting. You referred to my cause of action as a so-called right of privacy, and admitted that such publicity, quote, which some find agreeable, unquote, is to plaintiff very distasteful, and that I suffered mental distress, quote, when others would have appreciated the compliment to their beauty, unquote. And in an opinion 16 pages long, you arrived to the conclusion that I had no right that could be protected by your tribunal. To be perfectly fair to you, I ought to say that you expressly accepted from the effect of your decision any publication under similar circumstances which was in its nature libelous. It necessarily follows, therefore, when you now say that you reserve the right not to be photographed with your hands in your pockets or in other comfortable attitudes, either that you are asserting a right for yourself and your family which you are unwilling to accord the litigants before your court, or else that there is something in the attitude suggested of such a nature that a reproduction of it with photographic exactness would be necessarily libelous. It is not apparent how your likeness and attitude suggest it could be libelous, at least not as long as you kept your hands in your own pockets. I am forced to the conclusion that this incident well illustrates the truth of the old saying that it makes a whole lot of difference whose ox is gored. I sympathize with Mrs. Parker in her annoyance, but I know of no reason why you or your family have any rights of the nature suggested which do not equally belong to me. Indeed, as between us, I submit that I was much more entitled to protection than you. I was a poor girl making my living by my daily efforts and never courted publicity in any manner. I had never appeared before the public in any capacity nor solicited any favor at its hands. You, on the other hand, are a candidate for the highest office in the gift of the people of the United States, and that fact makes you the legitimate center of public interest. You are asking the suffrage of the American public, and the American public would seem to have some legitimate right of investigation. Your candidacy is something more than merely voluntary, and it may fairly be said that you have invited the curiosity which we both have found to be somewhat annoying. To this extent, at least, it would seem to me that the right which you denied me, but you now assert for yourself, was stronger in my case than in yours. If you will reread your opinion, you will discover that you lay down very clearly therein that you have no cause of complaint against these gentlemen armed with these cameras. They are acting strictly within the rights reserved to them by your decision, for in that document you distinguish my case from one wherein the party misusing my photograph had obtained it with the right to use it for certain purposes, but was using it in some other manner. In that case, you admitted that such use could be restrained. In effect, you contended that the rights of one who obtains a likeness surreptitiously are superior to those of one who buys the right to use it for one purpose, but uses it for another. Naturally, the camera fiends feel licensed to annoy yourself and your family in the manner which you yourself suggested, at least within the borders of the state. I sincerely hope that if you suffer annoyance of this kind in some locality where your decision is not controlling, you may be granted the relief which you denied me. Very truly yours, Abigail Roberson.
After that was published, the vast majority of newspapers across the nation applauded her response, although some did suspect that her lawyer had penned the bulk of the letter. I have to admit that was my initial thought also. From the July 29, 1904 publication of the Democrat and Chronicle, quote, "The public has seen, read, and enjoyed Miss Abigail Roberson's letter to Judge Parker. Now the public waits to be similarly entertained by Judge Parker's answer to Miss Abigail Roberson's letter." The Elmira Advertiser wrote, quote, "Miss Roberson has scored heavily and cleverly. There is no possible escape from her logic. Parker the citizen has no right to object to the law and the ruling of Parker the judge. It indeed makes a difference whose ox is gored. His opinion and vote in this case and Miss Roberson's rejoinder are bound to cut something of a figure in this campaign." And from the Boston Herald, quote, "Miss Abigail Roberson, a young woman of Rochester, must be credited with scoring a fair hit on Judge Parker, one which, if he has a sense of humor, he will enjoy, although we do not see how he can make any reasonable defense. And it may not be altogether without influence, for many persons consider his judicial decision in the case to which Miss Roberson was a party as strained, unreasonable, and contrary to common sense," unquote. As you could probably predict, Judge Parker never offered up a response, and that decision may have played a part in him losing the election. Teddy Roosevelt won in a landslide. He got 56.4% of the popular vote, while Parker only secured 37.6%. By the time the Democrat and Chronicle had caught up with Abby in 1967, the Franklin Mills Company was defunct, while the Rochester Folding Box Company, it had been acquired by the Weyerhaeuser Company, which of course is one of the largest lumber companies in the world. As for Abby, she told how one of her brothers had paid her way through music school and that she spent the next 40 years playing piano mostly in silent movie theaters, but also in churches and similar establishments. In fact, she lived for many years at 1823 7th Avenue in Troy, New York, which just happens to be a short distance from my house. Now that building is long gone, but I have passed it many times, and that's because the Department of Motor Vehicles is right across the street. Anyway, later in her life, in the late 1960s, she moved to Salem, Oregon to live with her niece. Abigail May Roberson died in a hospital there on Tuesday, May 17th of 1977. She was 94 years old, and to think they thought she'd never live past 21. So I'll leave you with one final thought. Abby may have lost her case, but it really became a win for everyone else. I mean, today no one would ever think of placing an image on a poster, in a book, or in a magazine, or in a video without first asking for permission. And we can thank Abigail Roberson for that. Useless, useful, I'll leave that for you to decide. Now, I've been collecting documents on Abigail Roberson's story for quite some time now, I'm guessing a few years, but I just kept pushing off the writing of the story. Why? Very simple. It's just tedious to read through some of these legal writings. I'm not sure why, but judges and lawyers, they just like to write these incredibly dense run-on sentences. You can have this lengthy paragraph, and it turns out it's just one long sentence. And for an average Joe like me, that's tedious and difficult to read. But, I took a week off from the podcast for Christmas and the New Year, so I felt a bit refreshed and decided to take it on. Now, my understanding is that Abby's case is well known among those who've studied law, so if that includes you and I've misinterpreted something or left out an important detail, please don't be too harsh on me. Anyway, the Useless Information Podcast is part of the Airwave Media Podcast Network, so be sure to visit airwavemedia.com, and there you'll find a curated selection of some of the best podcasts out there. Well, I hope everyone's New Year's off to a great start, and as always, thanks for listening. And take care, everyone. Bye.